reading the
May I
bylaws.
put again 2 cents? If ever a petition is drawn to remove me as a director, I will not challenge if the 25 or even less percent of the people will ask me to be removed, because I as a director represent entire galaxy. Yes, I was elected in Tower 2, but I don't feel that I only represent one district.
But that's not the way you were voted in. You were voted in by the one district.
Yeah, but you see, in particular, director from Tower 2 should be, I mean, it's a bigger honor because more people asked for the director from a district to be removed. Because from Tower 2, it's only 75 people, if I'm not mistaken.
I think
But then you
this
have
is going to be an
318
issue where I'm
signatures.
going to say we have to table it till the other 2 directors are here.
Well, I would, I'm sorry, I didn't mean to cut you off, because I'd like to provide my point of view now.
Please,
so
Stephen.
But I didn't mean to cut you off, I really
That's all right.
apologize. Okay. I believe, and I will just state it up front, I believe that the language, as I've said before, of the bylaws is unambiguous and dispositive. So I will now read Article 3, Section 5. It's entitled, the paragraph is entitled, Removal of Members of the Board. At any duly held regular or special meeting of the unit owners, any one of more, and I would say sick in there because it clearly means any one or more directors, may be removed with or without cause by majority of the unit owner votes present, and a successor may then and there be appointed by majority of the remaining directors to fill the vacancy thus created. I call your attention to the specific language. May be removed with or without cause by majority of the unit owner votes present. Since the unit owners will be present at the special meeting for the entire association, it is clear by that language that the bylaws don't ask for an opinion, they direct that it be a vote of all of the association and not of the district.
I didn't hear district.
That's my opinion.
Stephanie?
But that's for the vote. That's not for the petition.
Right.
There's no clear language regarding the petition.
Actually, that's not correct either.
Well then, give us that one.
Section 3, special meetings. Stephen?
Good that I printed it out. Yeah.
I
Can I
actually
read it?
printed it out too, but
I
I
have
left
it.
it upstairs.
Section 3, special meetings. After the first annual or special meeting, special meetings of unit owners may be called by the president whenever he deems such a meeting advisable, or shall be called by the secretary when so ordered by the board, or upon the written request of members representing not less than 25% of all the votes entitled to be cast at such meeting.
entitled could also mean entitled for that district.
It does not say entitled, it says entitled to be cast at such meeting. And since the meeting is separately defined as a meeting of the entire association and not of the district, and you have to read the two sections concurrently and not separately, since it defines the meeting as a meeting of the association and says all votes entitled to be cast at such meeting, it is, in my judgment, unambiguous that this defines the entire association as voting.
We have a motion on the floor,
Right.
but the topics that we're trying to deal with are instructions to Mary Ellen for counting and validating the signatures. That can be done in an overall sense without dealing with this issue, I think.
That's true. We may want, we are capable actually of revisiting once a report is generated. However,
Okay.
So-
bear in mind that if we want to do this as quickly as possible, if there is no doubt as to this question, right now, if there were no doubt, then as soon as the trigger number is hit,
Yes.
then it would be the case for all districts and all the directors who are the subject of the petition, and there would be no further effort needed. On the other hand, if we leave this question open, you would then have to go back and see
That's correct.
whether it was true for Tower 2. So as a matter of economy of effort, we ought to decide this question now.
Well,
So,
My
Lisa, what you're
opinion.
saying, if tomorrow, forget about this particular, we're setting a precedent. If 5 years from now or 2 years from now, there will be another motion, another petition to remove a director from Tower 2, what you're saying is that you would allow residents from Tower 2 to draw their own petition with 75 signatures to call for a special meeting. But then how do you
Who are
call
you
for a
saying
special
you?
meeting in one tower?
Who are you saying you?
She's talking
Stephen?
theoretically.
I'm speaking to, I'm sorry, I'm
Theoretically
speaking
about
to either
himself.
Lisa or to Stephanie.
Oh, okay. Not
So in
me.
other words, if we're going to go along and say, yes, in Tower 2 they have to draw 25% of Tower 2, let's take one step further. 5 years from now, people are not happy in Tower 2, they put together 175 signatures or 120 signatures, and they can call a special meeting of what? Then we're going to be creating new bylaws. They cannot call a special meeting. I, as the resident of Tower 2, I don't have a right to call for a special meeting of Tower 2. It's never you do not see this language in the bylaws. So I think that we should treat all the directors equally here.
Correct.
I would tend to agree. Bob, you
Well
have any comment
said.
to that?
Well said.
My only comment is that one can make another argument. It's your decision.
Okay.
I'm ready to
Mr.
call this
Bakalu,
question.
explain to me how would I remove a director from Tower 2 only getting signatures from the residents of Tower 2?
That doesn't make sense.
How do I remove it? Because we're going to set a precedent for new generations to come. So how do we set a precedent right now when we're going to vote on this particular issue? What would happen 5 years from now if unit owners of Tower 2 will not like sitting director?
I think your argument is clear, Slava, and I think we could call it vote to question.
Thank you.
Would somebody like to call the question?
Well, to recap the motion, it
Recap
is,
the motion.
just to help the board, to recap the motion, it is that the standard we're adopting is that the threshold is 25% of all unit owners for each of the directors
Entitled.
entitled to be
To vote,
voted.
as you
According to the
previously-
formula we already discussed, which is reduced by the number of total units that are in arrears, as well as the units which are owned by GTCA.
Right. Clear to everybody?
Yes. Yeah.
All in favor?
I'm in favor.
Favor.
Opposed? Lisa, any abstentions?
What's the count?
6.
1, 2, 3,
Six
4,
and
5, 6.
See, this is going very quickly.
Okay, what is our next issue?
May I ask a question of our council, John?
Yes, Lisa.
Mr. Bakalu, I'd like you to comment on a statute, a New Jersey statute, which I read, and it states only 10% of the votes required to call for a special meeting. Would you elaborate a little? What is your position? What should be our position here? What takes precedent, bylaws or New Jersey law?
Well, you're following the provision in your bylaws. But are you suggesting that if there's only 10%, the petition is good for calling a
No,
meeting?
I will tell you what
I'm
you're
asking
saying.
you a question. I'm not suggesting anything because I interpret the statute which I read, and again, I'm a layman here. I just read 10% there, and it states that 10% is enough to call for a special meeting. I'm just asking you your opinion. Because in some of the comments which you made to us, you do state that the New Jersey law takes precedent more important than bylaws.
Well, if your question is, does that statute somehow take precedent over this
Yes.
particular
Yes,
bylaw?
yes.
No. No,
And-
this,
So some
you're
other
following...
statutes do and some statutes don't,
No.
right?
Well, they're talking about two different things, Slava. You've got a procedure here for calling a special meeting for the recall of directors.
Hmm.
So that's the procedure that you're following.
But in your comments, you did not answer my question. In your comments, you stated, I don't have it in my hand because I don't have a printer here, but you stated that some of the New Jersey laws are more important in simple language than the articles of our bylaws. So we should go by the New Jersey law. They
Right.
take precedent. My question to you is such, is it true that New Jersey law mandates that upon receival of the 10% of the signatures or special meeting must be called? Or this is, I'm not interpreting, my question is such, am I interpreting, do I interpret this correctly or I am mistaken?
Well, I really, I don't know how to respond to you, Slava, because I don't know what you're trying to get at. And
No,
it has
I'm not
noth-
trying to get at
it
it.
has
I'm trying to
nothing-
get clarification.
It has